Good afternoon, and welcome to the Alliance for Health Policy's special webinar about the Texas Federal District Court ruling on the Affordable Care Act. I am Sarah Dash, President and CEO of the Alliance for Health Policy, and I will be facilitating today's discussion. For those who are not familiar with the Alliance, we are a nonpartisan organization dedicated to advancing knowledge and understanding of health policy issues. We do not advocate or take any policy or political positions ourselves, but our core mission is to educate the health policy community. During today's special webinar, our panelists will unpack the implications of last Friday's Affordable Care Act ruling from the United States District Court for the Northern District of Texas. Our panelists will explain what this ruling means for the courts, Congress, and healthcare coverage. I want to briefly orient the audience to the GoToWebinar platform and briefly review some technical notes. We've taken a screenshot of the attendee interface. You should see something that looks like this on your computer desktop in the upper right corner. You can click the orange arrow to minimize and maximize this menu. When you joined today's webinar, you were muted, and you will be throughout the presentation. Please use the question panel to chat with us about any technical issues you may be experiencing. You may also send in questions you have for the panelists at any time. We will collect these and address them during the broadcast. Finally, all webinar materials are available to download in the handout section of your attendee interface. You'll also find all the materials that accompany this webinar on our website, allhealthpolicy.org. This slide also includes a link to a previous Alliance webinar about healthcare in the courts, featuring Tim Jost and Mary Ann Pazanowski. This webinar contains some useful background information about this case. Finally, a recording of today's webinar will also be made available on our website. Here is our agenda for today. Each of our panelists will make 5 to 10 minutes of opening remarks, and we will use the remaining time to take questions from the audience. As a reminder, you can submit questions using the question section in the audience interface. Now, I will introduce our panel of experts. Joining us today, we have Katie Keats, an adjunct professor at the Georgetown University Law Center, where she teaches courses on the Affordable Care Act and health law and policy. She also maintains a part-time appointment at Georgetown University's Center on Health Insurance Reforms and provides Following the ACA Rapid Response Analysis for the Health Affairs blog. We have included a link to Katie's most recent blog post about the Texas court ruling on the additional reading slide, which you can access on our website. We are also joined by Rodney Whitlock, the Vice President of Health Policy at ML Strategies. Rodney is a veteran healthcare policy professional with more than 20 years of experience working with the U.S. Congress, where he served as Health Policy Advisor and Acting Health Policy Director for incoming Finance Committee Chairman Chuck Grassley of Iowa, as well as earlier on the staff of former U.S. Representative Charlie Norwood of Georgia. Our third panelist is Elizabeth Carpenter. Elizabeth is a Senior Vice President at Avalier Health. She specializes in the implementation of the Affordable Care Act, trends in commercial insurance, drug pricing policy, and the impact of politics on the policy landscape. Elizabeth began her career on Capitol Hill for the legislative and campaign staffs of Senator Lincoln Chafee. We are so grateful to all three of you for joining this webinar. And with that, I'll turn it over to Katie Keats.
Great, thank you, Sarah, and thanks for hosting this important conversation today. I'm going to try to keep things brief and really focus on an overview of the case, sort of what the decision last Friday was and where things are now procedurally, and then I'm happy to answer questions that folks might have. So to understand how we got here, we have to go back in time a bit to 2012, to when the Supreme Court ruled that the individual mandate could not be upheld under the Commerce Clause, but could be upheld under Congress's taxing power. As a tax, this case is the NFIB case brought by National Federation of Independent Businesses. You'll hear me refer to NFIB a number of times today. The new lawsuit, fast forwarding 6 years, the lawsuit Texas v. Azar, is really an attempt to revisit that NFIB decision from 2012, now that Congress has reduced the individual mandate penalty from $695 to $0 beginning on January 1st, 2019. That change to eliminate the penalty was made in the Tax Cuts and Jobs Act from last December, which was adopted under budget reconciliation procedures. The lawsuit itself, Texas v. Azar, was filed in February of this year by 20 Republican attorneys general and governors. They were later joined by 2 individuals who live in Texas. Collectively, these plaintiffs argued that the mandate will be unconstitutional beginning on January 1st, 2019. Their position is that without a penalty, the mandate itself can no longer be upheld under Congress's taxing power under NFIB. Now that no revenue is being collected under the mandate, it should no longer sort of meet the standard outlined in the NFIB decision. They go further, however, to argue that the individual mandate itself is so central to the rest of the ACA that they asked the judge to strike down the entire Affordable Care Act alongside the mandate. In asking for this, the plaintiffs rely heavily on the 4 justices Scalia, Kennedy, Thomas, and Alito, who dissented in the NFIB case and indicated that they would have struck down the entire Affordable Care Act then. The case itself was filed before Judge Reed O'Connor, who is in the Northern District of Texas. He has presided over a number of other Affordable Care Act cases now and in the past. In May, Democratic attorneys general from 17 states were allowed to intervene in the case to defend the ACA and its protections in their states. This was followed by a rare decision, a rare announcement from the Department of Justice in June that the Trump administration partially agreed with the plaintiffs that the individual mandate and major Affordable Care Act provisions like community rating, guaranteed issue, and pre-existing condition exclusions should also be struck down. Oral arguments in the case were held in September, and that was followed by a period of relative silence until Judge O'Connor released his decision last Friday, where he declared that the entire Affordable Care Act is invalid. A few important things to know about this. This was a declaratory judgment from Judge O'Connor. It was not an injunction. That means that the Affordable Care Act remains in effect. And so far, HHS and other federal agencies have stated that they will continue enforcing and implementing the law. It's really key. This should not affect folks' coverage for 2019. People should continue to pay their premiums. There should not be any immediate disruption as a result of this decision. There was, of course, a flurry of activity after the decision was released on Friday. This case will certainly be appealed to the Fifth Circuit and likely the Supreme Court. Right now, there is really just a question of timing of when that appeal happens. There's some procedural peculiarities in the case that have led to a question of whether the case itself should sort of remain before Judge O'Connor until the rest of the lawsuit is resolved, or if his decision can be appealed immediately to the Fifth Circuit. In normal course of business, decisions can typically be automatically appealed. That's not the situation that we're in right now, given some procedural peculiarities. This one reason on Monday, you saw the Democratic attorneys general led by California ask Judge O'Connor for 2 things. First, they've asked for a stay of his decision. They want a confirmation that the Affordable Care Act does in fact remain the law of the land and will remain in effect even after January 1st when the penalty goes to 0. I think that's everyone's expectation right now, but they're asking that this be put in writing and confirmed by the court. Second, they want a final judgment so that they can actually appeal immediately to the Fifth Circuit without a delay. They asked for this decision by Friday, December 21st, in 2 days. Yesterday, Judge O'Connor asked the plaintiffs and the Department of Justice to respond to this by December 21st. So we will know more on Friday about sort of what position the Trump administration in particular is going to take on how quickly the case should be appealed. Hopefully, I think Judge O'Connor, ideally will make a decision on whether he's going to grant California's request before the end of the year. I will sort of leave things there. That kind of tells you where we are. I'm happy to talk about kind of the merits of the decision, the way that the judge got there, answer questions regarding that. Elizabeth will be covering this too. I do think it's safe to say that if Judge O'Connor's ruling is affirmed and the entire Affordable Care Act is invalidated, it would affect nearly every American and every part of the healthcare system, but I know she's going to touch more on that. So Sarah, I think I'll turn it back over to you from there.
Great. Thanks, Katie. So I'd like to ask you a brief follow-up question before we turn it over to Rodney. And so you mentioned that the issue is timing as to whether when the case will be appealed to the Fifth Circuit and then to the Supreme Court, is there a minimum or a maximum amount of time that this might take? Like, when is the earliest that the Supreme Court might be taking this up, if they take it up?
Great question. I don't think, even if the case were to be appealed to the Fifth Circuit right away, I don't see a pathway to getting this to the Supreme Court before the 2020 term. So we might be sort of living in a little bit of limbo, which I think many folks are familiar with on the Affordable Care Act. There's also a chance that if Judge O'Connor keeps the case and we, have to do a few more procedures at the district court level, it could get stretched out to the 2021 Supreme Court term potentially. So nothing coming soon. It would sort of be a matter of years.
Thanks, Katie. So we'll now turn it over to Rodney Whitlock, the Vice President of Health Policy at ML Strategies, who's going to tell us a little more about the congressional implications of this case. Rodney, please go ahead.
Well, didn't the world just get more interesting late Friday night for us all? I think that if you're looking at Congress and the way Congress was expecting this to play out, the vast majority of the Hill, folks on the Hill would have told you they expected this judge to rule in favor of Texas. The fact that the judge ruled in favor of Texas was not an earth-shattering surprise by any stretch of the imagination. What caught people off guard was the fact that he ruled the entire act unconstitutional. That changes things, and I'll walk through that for you here momentarily. So Congress can do something about this decision. It is available to them relatively some simple ideas. One, they could pass a law that speaks to severability, or two, they could turn the individual mandate penalty back on to $1 or something like that would effectively invalidate the decision. There are things out there that they could knock around. I think one has to keep in mind that with a Republican Senate and a Republican administration, it's highly unlikely that anything could be done legislatively. So instead, let's talk about what really will be happening in Congress here as we look to respond to Texas versus Azar. I think that the House of Representatives, particularly in control of Democrats, were expecting this decision to invalidate Title I, and that's where all of the patient protections are and the structure that puts the marketplace in to work. We expected that to be done. So I thought prior to the decision coming out, the expectation would have been the House would vote to join the lawsuit and saying that that Texas is effectively wrong. And then they would have talked about pre-existing condition protections. How this changes now is that the entire act is available for legislative conversation, hearings, votes on the House floor particularly. Will the Senate be drawn in? What I think we'll be watching for in early 2019, certainly the first quarter now, is a lot of conversation about the Affordable Care Act and the consequences of this decision at a time where the decision really has no immediate real-world impact. And so it'll be very political conversations, a lot of allegations, a lot of screaming and yelling, rending of clothes about what happens if the biosimilars provision were to be stricken from law. What about all of the accountable care organizations, CMMI, the Center for Medicare and Medicaid Innovation? It exists out of the Affordable Care Act. What happens if it were to suddenly go away? Would those people not come to work? There's going to be a lot of drama over that. Not saying it will make any specific differences in terms of real-world impact of legislation, but for Democrats looking at this, they know that holding Republicans' feet to the fire may be of some value. How much value? I can't say for sure, but I'm very certain it's non-zero. And with that, I'll pause and let you ask me anything, Sarah, and move on, and I'll answer questions later.
Great. Thank you, Rodney. So I don't think I have a follow-up question for you at this point, but I'm sure we will after Elizabeth, and then we'll get into a broader discussion. So let me now turn it over to Elizabeth Carpenter, Senior Vice President at Avalier Health. and she's going to tell us a little more about the implications of this ruling for the industry and for consumers. Elizabeth, go ahead.
Thanks, Sarah, and thanks to Rodney and Katie for teeing things up so nicely. So when I think about the impacts associated with this ruling, I think it's important that we consider sort of the immediate or near-term implications and separate those from some of the longer-term potential consequences, which we can also address. But, as Katie and Rodney both alluded to, it is important to sort of leave this audience with a clear understanding that there will be sort of no immediate market impact for the 2019 plan year. So for the plans that have signed up to offer exchange coverage for the people who just picked a plan for the 2019 plan year, we really are proceeding under the status quo. So that is an important takeaway. When we think about the near term, I really do think one of the biggest issues is uncertainty. And we've seen, I think, Sarah, as you alluded to, various points of uncertainty throughout sort of the evolution and implementation of the Affordable Care Act. And we do know that it has some impact on industry and on patients in particular. So as Katie mentioned, assuming that this all may not be wrapped up till 2020, you sort of have to fast forward to that period of time and think about, okay, if I'm a health plan, for example, preparing to bid for the 2021 plan year, or preparing to submit premiums to my state Department of Insurance, sort of what world am I operating in? And this isn't the first time we've seen this. Obviously the debate over the tax credits was something that was playing out during this process. Similarly, the uncertainty associated with the cost sharing reductions was something that played out during the plan rate submission process. And in fact, we had many states allow plans to submit two versions of rates, or in fact to revise their rates once we had a sense of how the administration would approach that particular issue. So, I think this is something to keep an eye on. Obviously, for 2019, we've seen a good bit of stability in the market in terms of premiums and plan participation, and sort of this ruling just re-injects some uncertainty in a market that I think finally had some certainty going into this year. And so, the other piece I will flag as well, Rodney said, that it's unlikely to see, meaningful sort of legislative action. I encourage everyone to keep an eye on the states. Much like the individual mandate repeal, we could see some activity in various states to shore up certain provisions of the Affordable Care Act in anticipation of, further rulings. And then I think, from a state perspective, we also have states out there, obviously, that are depending very much on the Medicaid expansion dollars included in the ACA. And you could see some hesitancy on a part of some states to jump in 2 feet to that expansion conversation. We know there are some in play. And in other states, you may just see sort of additional caution and focus on sort of managing that Medicaid population, sort of hedging their bets in case something pretty significant were to happen. And then finally, I really do think that we could see some patient confusion as a result of this ruling. We've seen this before during the debate over repeal and replace. I think there were some polls out there where people were confused about whether the Affordable Care Act was still the law of the land, especially after some of the debate in the House. And what we've seen thus far is pretty intense media coverage of the court case, and I think that really could sow some confusion among the patient and consumer community, which is likely only to intensify, frankly, as 2020 approaches, and as Rodney sort of highlighted, this becomes an even more sort of political hot button issue. So that's sort of the kind of near term or more immediate term thinking. Longer term, if the ruling were to stand in its current form, I think, as Katie alluded to, there are a whole host of issues that people are just starting to wrap their heads around, sort of however unlikely it might be that we end up in that place. It is, sort of worth going through. So, the first bucket is definitely the coverage and sort of the various patient protections included in the Affordable Care Act to give everyone on the line a sense. We have about 8 million subsidized exchange consumers at this point, about 6 million unsubsidized lives, but that are, sort of living under these sort of new market rules, about 12 million people who gain coverage under Medicaid. We have about 2.3 million people, a little over 2 million people, HHS estimates, are taking advantage of the dependent coverage up to age 26. And then, 5 million or more seniors who are benefiting from the changes in the coverage gap, So, there are a host of other provisions, things like preexisting condition exclusions, out-of-pocket max, and the like, which really bring in a wider range of people, including those employed and who are accessing sort of traditional employer coverage. So it certainly would have kind of wide-ranging implications from a coverage and access standpoint. Again, from a state perspective, there is the particular implication associated with the Medicaid expansion dollars. I think the estimates out there are about that states are scheduled to get about $63 billion from the federal government for the Medicaid expansion in 2020. So there's a good bit of money at play here. And then there's some real potential impacts on state insurance markets. Some states, following the passage of the Affordable Care Act, sort of adopted the ACA patient protections whole cloth. Others, in their statute, reference very particular areas of the ACA, sort of tying their state insurance law to the Affordable Care Act. And then some didn't do anything, really making them entirely reliant on the future of the federal law. So, to close, I would just say, in addition to some of the issues that Rodney highlighted, things like the Center for Medicare and Medicaid Innovation, the payment reforms, the changes to providers, biosimilars. We also had, for example, very significant changes to Medicare Advantage payment as part of the Affordable Care Act. So I think at no point, even during the repeal and replace debate, did sort of industry or stakeholders think that some of those changes were really on the table, and certainly this ruling sort of put some of those changes in play in a way that really hasn't been the case.
Thanks, Elizabeth. So we already have an audience question, and I'll ask it because it relates to what you said about patient confusion. As we know, the judge issued his ruling the day before open enrollment closed for the healthcare.gov, the federal marketplace. Do we know anything yet at this point about the impact of that ruling on enrollment, or do you have any speculation?
I think it's going to be hard to tell even once we get, some of the final enrollment numbers. We saw that enrollment was lagging a little bit behind this year to begin with. So if for some reason we sort of end up with an enrollment number that is, lower than folks projected or had anticipated, I think it's going to be really hard to isolate sort of the impact of this case in particular. We do know that people signing up on exchanges historically, really have sort of come down to the deadline in some ways, and it would be hard to imagine that there's no one that was confused out there, but it's hard to say exactly how many people.
Great, thanks. So let me now ask Rodney a follow-up question on pre-existing conditions. I think we've heard that word quite a bit over the last few months, and I think as we talked about on a previous webinar about the election impact, that was first and foremost in a lot of voters' minds. So how do you see this playing out in the next Congress? Will there be real legislation on it? Will there be a lot of message bills? Tell us more about that.
I think we'll see much more message bills than real action. So reality is that the Affordable Care Act is still in place, which means the Affordable Care Act pre-existing condition protections are still in place. So that's why you're going to see more, again, I used the word drama earlier. You're going to see those types of actions that are are more for show than specific activity. I don't think you'll see Republicans in any way engage to try to solve problems around them, because they will argue there aren't actually problems until this court case moves further along and may have real teeth, which we are, again, as I think Katie walked through, is we're quite a while away from that happening.
Thanks. Let me ask you another congressional question, which is, just given the perception, given that the whole Affordable Care Act, not just Title I, might be kind of thrown open for debate, how do you think that's going to influence, does that just add fuel to the fire for, a debate around replacing the Affordable Care Act in any meaningful way?
I don't think it draws Republicans to the table to want to re-engage in a full repeal and replace conversation. And the reality is that through much of 17, Republicans kept in place the vast majority of the ACA's infrastructure outside the first couple of titles. There was never a conversation about repealing accountable care organizations, the Center for Medicare and Medicaid Innovation, or the biosimilars provisions. So I think you're going to continue to see Republicans will talk about their vision of healthcare, but it will be less, spurred by Texas versus Azar. We have to have this in place when the law is brought down. I don't think Republicans are feeling like that is a particularly valuable conversation at this point.
Thanks, Rodney. So we have an audience question, and it goes to Katie Keith, but anyone can jump in. I'll give Katie a chance to respond first. And the question has to do with the individual mandate itself, and basically whether it is essential to the insurance market reforms working or not, and sort of how much of the court's decision revolved around that. Can you comment on that?
Yeah, great question. So I'll give a little bit of where the court landed on this question, and then some thoughts from me, for better or worse. Judge O'Connor came to this conclusion, frankly, that the mandate was essential to the entire rest of the ACA by looking at legislative findings that were included when the ACA was passed in 2010. I think if you look at those findings, they do seem, at least to me, to be limited to sort of the Title I of the ACA that my colleagues have been talking about quite a bit. It seems a bit of a stretch to me that you could say the mandate is essential to the Center for Medicare and Medicaid Innovation or biosimilar pathways, for instance. But he's really taking and kind of seizing on that language that the mandate is essential to creating health insurance markets, and that's what he is looking towards. There's also, it's a bit of a shell game, to be honest, where, he goes, in his decision, he sort of goes through and says, if we don't have the mandate, the sky will fall. Insurance companies will have to pay billions of dollars, they'll lose customers, all of these sort of, a parade of horribles, if you will, of all the bad things that would happen without the mandate. I think the thought for me and the reaction to that is, in fact, things have been fine without the mandate. I think if we're in this environment actually for 2019 where the penalty has been zeroed out, and you actually saw premiums in a marketplace, as Elizabeth said, that was relatively stable. Average nationwide premiums went down slightly. You saw a number of insurance companies returning to the market, and enrollment's lagging a little bit, but things seem like they're going to be fine. And so I think there's this argument that we're looking at this language in the legislative findings and saying you absolutely have to have this or the market's going to crash, that frankly has not been borne out by reality, especially for 2019. So, in short, I think we are seeing 2019 sort of shows us that the mandate might have been thought to be essential at the beginning. We are clearly seeing now that maybe that's not the case. And it does seem that, the premium tax credits and the subsidies and there are other drivers of enrollment that are sort of keeping the marketplace stable, even in the absence of a mandate.
Thanks. And let me do a follow-up, and maybe Elizabeth will want to weigh in here as far as the state action. are some states nonetheless taking action to try to institute an individual mandate in their states in response to the tax bill from earlier this year?
Yeah, we have seen a number of states, implement individual mandates in their state, and then obviously there's been, some other states that have discussed it. So that's sort of where we go back to states taking some of this in their own hands and seeing sort of what, evaluating their state laws and seeing particularly some of the blue states, what they might need to do or what they maybe are able to do to sort of hold off or protect their state from a potential eventual court ruling.
Thanks. And can you go a little bit, Elizabeth, just go a little bit deeper? You touched on this some, but do you have any thoughts as to whether the uncertainty around the court case may cause states to delay efforts to expand Medicaid for those that haven't yet expanded, or perhaps revise their efforts around Section 1332 waivers or other initiatives like that?
Yeah, I guess I would say a couple of things. There are a few states where election outcomes sort of put Medicaid expansion on the table. There are a number of forces that would need to align to ensure that happens. But, certainly an argument that we heard, when states were deciding whether or not to expand Medicaid in the first place was, well, we are not sure that this money is going to be there for forever, and we're sort of taking on this group of people, and what if the federal government yanks or changes our funding? And, we really saw an outcry, frankly, during the repeal and replace debates from governors about sort of the changes to federal funding for the Medicaid expansion. So, I don't want to create the impression that there's a direct cause and effect here, but certainly as the debate unfolds in some of these states where Medicaid expansion is not a foregone conclusion, you certainly could imagine that sort of this uncertainty could play a role in the discussion, particularly among folks who are not in favor of the state expanding. And then, I think more broadly, it is very interesting to sort of consider the intersection of both new federal regulations as they relate to sort of non-ACA compliant plans and the new 1332 waiver flexibilities. I think there are some people who have been super focused on how that intersection could lead to sort of more non-ACA compliant plans in certain states. The flip side is that the 1332 waiver flexibility gives some other states the opportunity to design kind of their own programs. Now, of course, if down the road the entire ACA for some reason were to be struck down, then the question is, the money that they would be using, or the 1332 waiver authority in and of itself, potentially wouldn't exist. So, I think it is something that will be kind of in the minds of states as they consider their next steps, and it's just sort of one more, piece of the puzzle as they decide what to do next.
Thanks. So I have another question about a policy implication from our audience. And as a reminder, if you have a question and you're in our audience, you can ask your question through the question feature in your toolbar on the right-hand side of your screen. So this question, I'll kick it to Rodney first, and then open it up for other panelists. There were obviously some efforts in over the past year or so around market stabilization, premium stabilization efforts at the federal level, as well as in the states. And I wonder if you could comment on whether you see those efforts continuing, whether you see the court ruling having any impact on those, and how you see that moving forward.
Sure. So on the federal level, in 2017, during a lull in repeal and replace, there appeared to be an effort on a bipartisan basis between Senators Alexander and Murray to try to do something that to stabilize the Affordable Care Act marketplaces. They had productive conversations, but were never able to, lack of a better word, close a deal on something there. That is certainly something that could be brought up. But I think the thing that will need to happen for any conversation to be productive in that space is going to need to be leadership from the White House. I think Republicans particularly will be needing significant buy-in from the White House that they should be working in that direction for them to move towards something that looked like making peace with the ACA. So until signals like that are shown, it's hard to see necessarily anything happening there.
And Sarah, if I could just add, if you go back to what was in the Alexander Murray bill, some of those issues are not really on the table anymore. So, a piece of the bill was 1332 waiver flexibility. That's something that is, moving at this point via regulatory authority. There were provisions around the cost sharing reductions, and sort of that has already played out in the market. There was a big focus on reinsurance to sort of try to stabilize insurance premiums. So whether or not Congress talks about quote unquote stabilization, I think sort of the political or frankly practical impetus for that discussion will be different, because I think the situation is different than it was, as Rodney said, towards the end of 2017.
Thanks, Elizabeth. Okay, so we have a bunch of questions from the audience about some of the legal procedure. So Katie, tag, you're it. The first question was, why do you think the judge made his decision a declaration rather than an injunction? And is there any chance he could still issue an injunction on the ACA before the case is appealed to the Fifth Circuit?
Yeah, great question. So I think he issued a declaratory judgment in part because the Department of Justice asked him to. This is something they sort of said in oral argument. We don't really need an injunction. We can treat your declaratory judgment like an injunction. We will follow the order that you give us. And so we don't need you to go so far as to enjoin the entire Affordable Care Act or whatever it is that you, Judge O'Connor, decide to enjoin. There's some merits of doing that. I think the plaintiffs are still going to press on for their preliminary injunction and then a permanent injunction. But in the meantime, I think it is important, again, that the declaratory judgment itself just means that nothing has been set aside. The ACA remains in effect. That said, yes, Judge O'Connor could still issue a preliminary injunction. I think if he did that, I think all of the parties, to be honest, would file for an immediate stay of that injunction. So again, it would not disrupt the status quo, even if he were to have issued a preliminary injunction. If he does do that, that would allow for an immediate appeal to the Fifth Circuit, and we wouldn't sort of be in a little bit of procedural limbo, at least for maybe the next 2 weeks. So, all options are sort of still on the table. It'll remain to be seen what happens by the end of the year.
Thanks, Katie. And as a follow-up to that, and to point to something you mentioned earlier around, several other aspects of the case that the judge might keep in his court and consider, can you say a little bit more about what those are?
Yeah, great question. So when the plaintiffs filed this lawsuit, they essentially included 5 different claims or challenges to the mandate, and then with it, the entire law. This decision that we saw on Friday really only addressed the first of those 5 claims. And so, basically this first claim was really focused on the taxing power and the Commerce Clause argument. The other claims focus on whether the mandate violates the Due Process Clause of the Fifth Amendment or the 10th Amendment. It's just a series of other sort of constitutional challenges to the mandate itself, and with it, the entire law. So I think, in California's filing on Monday, they're really arguing that the decision on Friday is sort of determinative. You could go up to the Fifth Circuit without needing to resolve these other 4 questions. You've already struck down the mandate and found that it's unconstitutional on one of these grounds. Why would we need to sort of wait and see what you're going to determine on the other constitutional grounds? And this is an issue of such sort of national importance that it should go up as quickly as possible. So it's really those sort of other 4 claims that haven't technically been determined yet that is putting it in a bit of procedural limbo, but again, hoping to kind of know more before the year ends about what exactly happens next.
Thanks, Katie. And so we'll know more on Friday if the judge rules on Friday about whether or not he's going to rule on those four additional claims. Is that correct?
So I think we'll hear, not quite. So we'll hear from the federal government and the plaintiffs on Friday about what they, California has sort of made this request that California wants a stay and wants an immediate appeal. On Friday, we'll kind of get word what the federal government's going to ask for and if the plaintiffs are going to agree with all of that. California will then have until December 26th to respond to whatever arguments the plaintiffs and federal government make. And then from there, Judge O'Connor would sort of make a decision about what he's going to do. So he'll have all the information he needs by December 26th. There is this concern that because the mandate, the penalty technically goes to 0 on January 1st, does that change? Does that become an injunction? Does that affect, whether the ACA stays in effect? There is sort of this push to try to get this question resolved and get at least a stay before the end of the year. So I think we'll know more, but potentially not until after the 26th of December.
Thanks. And let me just ask you one last question on this point, which is on these 4 remaining claims, if the judge were to rule on them, does that change the game? Does that change the nature of any further conversation either in the Fifth Circuit or for the Supreme Court?
It's a great question. I think the answer is no. I think, to the extent that anyone sort of accepts or relies on the rationale given in the decision, I'm trying to be very diplomatic about some of the merits of the case. I think the strongest grounds that they had were under the, this NFIB taxing power commerce clause. So I think trying to argue under maybe the 5th Amendment or 10th Amendment is even further afoot. So it seems like these were the strongest claims, and it would make sense to me certainly to have this go up to the Fifth Circuit now to get this sorted out, given how important it is.
Great, thanks. Okay, so we have a question about the House Democrats joining or intervening in the lawsuit. And Rodney, you had mentioned that. Can you say a little bit more about that? What does that effectively mean, and what can we expect there?
So I think I'd actually turn that one over to Katie to talk about the legal meaning of it. But the precedent was set when the House intervened in the lawsuit with regard to the cost-sharing reduction payments. And so there is the precedent that the House intervenes to speak effectively to the federal court about what they mean in legislation. And I'll open the door for Katie to speak further on the legal merits of that.
Yeah, that's exactly right. It would sort of give the House an opportunity to defend the ACA and talk about exactly what Congress was intending from their perspective during the Tax Cuts and Jobs Act. I don't know that it has a huge impact on the case and where things get settled, to be quite honest with you. I think a lot of those arguments are out there and being considered by the judge and will be at the Fifth Circuit, very much being represented by California and the Democratic attorneys general, but you might still see the House make that move.
Thanks. There's also a question about a Maryland lawsuit. And Katie, could you talk to us a little bit about how this ruling may affect the Maryland lawsuit or how those interact?
Yeah, so we are at a very meta place in ACA litigation where we're actually having lawsuits about ACA lawsuits. So Maryland, the Attorney General of Maryland, Brian Frosh, filed a lawsuit against the Trump administration recently, sort of earlier this year. It's not as far along as some of these other cases, but essentially arguing that the Trump administration is failing to kind of implement and enforce federal law based in large part on the position that the Department of Justice took in Texas v. Azar to not defend key Affordable Care Act provisions. And so by sort of taking that position in court, Maryland is suing to say you're failing to enforce federal law. They also are asking for sort of a declaratory judgment, same thing we've seen here, that the ACA is constitutional. So it's sort of parallel litigation, if you will. I know that it's ongoing. They had sort of been waiting until we got the Texas decision, and so I know things are sort of getting into higher gear in Maryland, where this is sort of pending now. I know right away the Department of Justice informed the Maryland court that the decision had come out. I think they were talking this morning. I haven't seen a readout of exactly how that hearing went to decide, okay, what happens next in this Maryland case now that we have the Texas case. But it's sort of the flip side of Texas, where they want a judgment that the law is in fact constitutional.
Thanks. Okay, so we have a couple of questions, the inevitable crystal ball questions. How do you see the Fifth Circuit and the Supreme Court reacting to this case or responding?
So crystal ball is always dangerous. I think the Fifth Circuit has a number of grounds by which to overturn this case. On standing alone, which for non-lawyers just means your ability to get to sue in the first place and bring the lawsuit. Judge O'Connor really only determined that those two individuals in Texas had the standing to bring this lawsuit. He didn't say anything about whether the states, those 20 states, could do it. Given some case law and other rulings in the Fifth Circuit, they've taken a pretty hard line on standing in a case like this. And so they could just look at this and go, you don't have standing to sue here. I also think on the severability analysis that there's going to be a hard look there. I will say the Fifth Circuit is a generally conservative circuit, so there's sort of no telling. There has been some conventional wisdom out there that the Fifth Circuit will sort of overturn this decision, and then the Supreme Court will deny cert in that case and refuse to sort of hear that case, which would kind of stop things there. I'm a little bit of an outlier where I think the case will probably go to the Supreme Court and will have to be decided there to keep additional challenges from coming back on this issue. I will remind folks, I think the same majority that upheld the individual mandate in NFIB remains on the court. And I just, even in a separate case in King v. Burwell, Justice Roberts has kind of indicated through his decision that he might be tired of looking at these lawsuits trying to overturn the ACA. So I think it's certainly going to be an uphill battle for these plaintiffs, and both at the Fifth Circuit and the Supreme Court. There could be some curveballs in there, some wild cards, but it is sort of a stunning decision when you read it to have the entire law be struck down, given a change from $695 to $0.
Thanks. Okay, so let me open this up now to a question, and I'll ask maybe Elizabeth to comment first, and then Rodney, and Katie, if you want to jump in. But the question is, of course, what are your thoughts on how this could impact the 2020 presidential election? Is this significant in that debate, or was that already going to be a pretty healthcare heavy debate?
Yeah, so to answer your second question first, I think everyone anticipated that healthcare would play a large role leading up to 2020, just based on, sort of the traction that healthcare had in this election and sort of the efforts by, Democrats, or the expected efforts by Democrats over, the coming 18 months or so to sort of solidify and form a platform on, frankly, taking ACA sort of to the next level, whether that be some kind of buy-in or, Medicare buy-in or public option, or, in some cases, a Medicare for all. So I think healthcare, both coverage and sort of prices, were very much positioned to play a role heading into 2020. I see this case really turbocharging that discussion. Obviously now proponents and supporters of the Affordable Care Act really have a rallying cry, which is, the entire Affordable Care Act is once again in jeopardy, and who you choose for president plays a significant role in the judges that make these decisions. And so, the media coverage and sort of the response from Democrats initially has been, pretty intense, and I would imagine that is only going to intensify leading up to 2020. And I would be interested in what Rodney has to say in terms of, I think it will put some pressure on Republicans to have, a retort to that and sort of a position on that. And it will be interesting to see how sort of both sides' positions evolve as this legal battle draws on.
So I'll jump in to state that the law of the land is the Affordable Care Act. And fascinatingly, neither party is madly in love with the Affordable Care Act. Republicans have hated it root and branch way back to 2010, but it's remarkable on the Democratic side to watch how much they are becoming enamored with a shiny object we often refer to as Medicare for all. And so what's interesting is, does this put Democrats in a position of defending the existing law more so than they would have otherwise? And does that have any impact on politics on their side for 2020? I mean, are you, I will step way out on a limb here to say I'm pretty comfortable no one is getting the nomination without at least giving fealty to the concept of Medicare for all. On the Republican side, Republicans are still in the ideological wilderness of a place where once upon a time Republicans could believe in using the federal government to organize the marketplace versus what is now much more of a there really shouldn't be a federal role, let's turn it over to states and hope it turns out well approach, which then obviously does not play well when you're talking about important concepts such as pre-existing conditions, as they found out recently.
Thanks. All right, let me ask Elizabeth a question a little bit more industry focused, and then I'm going to wrap it up with one more big picture question before we let everybody go on to their afternoons. So Elizabeth, there were a couple of questions about kind of how the industry might respond. Do you foresee any efforts to extend the moratorium on the health insurance fee and device tax? In the perhaps unlikely event that the entire ACA is struck down, do you foresee industry efforts to recoup some of the payment Medicare cuts or taxes that were paid under the ACA over the last 8 years? Both of those questions came from the audience.
Those are excellent questions. So, in terms of what role industry, might play until sort of this becomes settled from a legal perspective, I think you've heard Rodney say a couple of times the ACA is the law of the land. I think you will hear that from industry. And then I think, most industry groups will need to take some kind of position on sort of where they are. But I would imagine that, at this point, you will hear from a variety of stakeholders sort of reiterating that the ACA is the law of the land, the ACA is the law of the land, right? Whether, frankly, if the entire Affordable Care Act is struck down at some point, the spectrum of potential industry responses, I think lawyers could probably have, their own holiday party thinking through what on earth that would look like. So, I don't know if Katie has any particular thoughts from a legal perspective, but I think just conceptually, everything is in play if the entire ACA were to be struck down. And again, I think we're, a long ways from that.
Thank you. All right, let me ask kind of a final big picture question before we kind of close, which is, we've all talked about uncertainty on this call, and I think, the Affordable Care Act, as we know, has faced a series of legal challenges, some perhaps unexpected, that have at different times thrown the law into this state of uncertainty. And the question is, Do you think these types of judicial challenges will become the status quo for future pieces of legislation, comprehensive or not? Is this the new normal? And is this going to change how Congress writes laws?
So I think one of the things that, if you go back in the last couple of decades in healthcare, there have been controversial issues. The question is, when you have effectively really nasty partisan fights that don't go away, it does bring into question the not the validity of the law, but the support for the law. And so, go back to the Medicare Modernization Act. Wasn't completely bipartisan, but it was largely bipartisan. And I don't think it's questioned at the core, certainly not the way the ACA is. You look at the CHIP program, you look at the recently passed Medicare and CHIP Reauthorization Act macro, which changed the nature of the way physicians are paid. The lesson is always out there for Congress, which is partisan bills do lead to long, protracted fights that don't go away because those that weren't involved never ultimately accept the validity of the law.
Thanks. Katie, Elizabeth, any thoughts on that?
I would just echo what Rodney said in terms of, I think you will hear some people talk about the fact that sort of this protracted legal battle over the ACA underscores the, benefit of bipartisan discussion on important issues like healthcare. I think you will hear people say back that, well, if people don't want to have bipartisan discussions, then what are we supposed to do? And to your point, I imagine that if at some point in the future, one party or the other is writing, some kind of major piece of legislation that is, highly political, that certainly this is going to make sort of the legality of that drafting process even more in focus. Not that, Lord knows there was all kinds of discussion about the individual mandate and potential court challenges while it was being drafted. But, I think this experience will certainly play in the minds of staffers who are trying to craft and draft.
And this is Katie. I agree with all of that. I think but if this decision, again, is upheld, and there are real questions about whether it will be, it's going to have impact far beyond healthcare too, in terms of what Congress is doing and how these laws get crafted, and the idea that, again, a Congress 7 years later could go in and make a change that then invalidates the entire law, I think sets a very dangerous precedent. So I'm sure that's going to certainly be on the mind of Congress, but other judges, the entire sort of legal system is going to be very attuned to that. And I think it's another reason why this judge, may have gone a little bit too far as other people start to look at this and it works its way up through the appeal system.
Great. Well, thank you all. That is all the time we have left. So we're both out of time and out of questions for now. But stay tuned. As Katie said, we could see some more to this story as soon as Friday. So thank you all to our panelists for joining us for this special webinar. Thank you to everybody who listened in today. This is the Alliance's final event of 2018, but please stay tuned for additional programming early next year about this topic and more, and wish everybody a Happy New Year. This will now end the webinar.